for coming to the webinar. For those of you who don't know me, I'm Howard Ehrenberg. I'm the managing partner of SulmeyerKupetz, where I've been a practicing bankruptcy attorney for the last 34 years. I'm also on the panel of Chapter 7 bankruptcy trustees for the Central District of California. And most recently, I became certified as a mediator, and I am on the mediation panel for the Central District Bankruptcy Court. And I hope that the technology is going to work well today. I'm speaking to you from my home. Behind me is a virtual picture of my kitchen window. I hope the cat doesn't jump in my lap. I hope you don't hear the gardener next door, but if you do, I apologize in advance for any technical problems. I wanted to do this webinar today because I believe that mediation is a means of resolving problems that has always been around, but is especially important now that we're still in the midst of the pandemic and have few options for being able to resolve issues in person. So with that, we will get started. I've put up my PowerPoint, so hopefully you'll be able to see it. So first, as I said, I'm a big proponent of mediation. I think that when the parties can resolve their own problems without the need to go to a judge, that most of the time they're going to end up being better off. It's not a zero-sum game where there has to be one winner and one loser. Of course, sometimes people are adamant and they absolutely must win at all costs, and sometimes you're just not going to be able to talk people out of that. But I think that the statistics show that mediation is an excellent way of resolving problems. In the Central District Bankruptcy Court, more than 80% of the mediations that are ordered by the judges do result in settlement agreements. But I point out that a successful mediation is not one where everybody ends up hugging and singing Kumbaya. Instead, a successful mediation is where everybody is a little unhappy, but the matter is over and people can move on with their lives. It's also very important to point out that when doing mediation, the parties are saving an enormous amount of time, energy, and resources, including money, in that the cost of going to trial is generally much, much more expensive. So other than in the largest of lawsuits, where the cost of litigation is small compared to the outcome, in most of the cases that I deal with as a mediator, the cost of litigation is a major factor. And while one party usually thinks they're being sued unfairly and that the cost is unfair, the fact is it exists and it has to be dealt with. And the best way to try to deal with that is to get it resolved as quickly as you can and at the lowest cost possible. So since we can't do these in person, where the court says, go to the mediator's office and everybody sits in a separate room, we can't do those right now. Now, it's not the case that the office isn't available, but I have found that most of the people I speak with, at least someone is in a higher risk category or is from another place where they would have to travel from, or simply is uncomfortable being around other people. And I don't see that ending certainly before the end of the year. I've heard that many businesses are already telling their remote workers that they can work remotely through June of next year. So I think what we all need to do is learn how to conduct a mediation using technology as the next best thing. So today we're doing this webinar using Zoom. You may recall, if you've been to other webinars at the firm, it used to just be a telephone with no video. But now Zoom seems to have taken over the world. I didn't know what it was a year ago, but now it's sort of my best friend. And while there are other technologies, Microsoft and the other internet providers all have their own, I have found that Zoom is the easiest to use, especially for people who may not be highly technologically sophisticated. I put myself into that group, and I'm able to use Zoom with little difficulty. One of the benefits of Zoom as a mediation tool is it has the ability to create what's called breakout rooms. So when you set up the mediation with everyone's email, you can then assign the different people into different breakout rooms, meaning the plaintiff can be in one breakout room and the defendant in another. Sometimes you even have multiple plaintiffs and multiple defendants, and you can create essentially an unlimited number of breakout rooms. And then just using the control panel, the mediator can then go from one room to another. And so it's the functional equivalent of being able to walk from one office to another to speak with the other people. It's also useful to note that if it is appropriate, that you can pull someone out of a breakout room and put them into another breakout room. Sometimes we find that maybe if the lawyers speak together outside of the presence of their parties, their clients, that they can have some useful discussions. Sometimes it's useful to have the parties speaking to each other. Often these matters are very personal and emotional, and it is sometimes useful out of the earshot of the lawyers for the parties to just sort of talk it out, and maybe they can come to a resolution. Regardless of the situation, the idea of using breakout rooms and the ability to move people around is a definite technological benefit to a remote mediation. I highly recommend that you set up a test mediation in advance of the actual mediation. As I said, many people have not done this before. They may have difficulty logging in. They may have difficulty hearing. They may not have their camera in the right direction. They may not have their microphone on. And what you don't want is to spend half an hour people calling back and forth, trying to log in, figure out what the password is. There's a lot of things that can go wrong at the beginning. So I have now conducted several mediations using Zoom, and in each case I have had a test meeting 1 or 2 days in advance so that everybody can feel comfortable that on the day of the mediation they know what's required of them. You know, one of the main issues in mediation is to establish confidentiality. And whereas this webinar is being recorded and it's going to be up on my firm's website later for all to see, it is very important that the parties know in a mediation that everything they say is confidential. And so one thing that's very important to point out right at the beginning is if you are the mediator, do not push the record button. It is unfair to the parties who think that they are speaking confidentially, that they could be recorded for others to listen to later on. Sometimes people just want to vent. They need to get their feelings out. They're willing to tell it to their lawyer. They're willing to tell it to the mediator. They don't want it told to the other side. So it's imperative that confidentiality be maintained throughout the process. Part of that also is, if you haven't done a mediation before, I have a standard form, I'm sure all the other mediators do too, which states that everything said is confidential, and the mediator points out to all of the participants that unless someone says specifically that something can be repeated to the other side, it will not be repeated to the other side. So I think it's very important that both during the test and at the beginning of the mediation itself, that you remind all of the parties of the nature of the confidentiality. Mediation statements is something that I've been using for quite a while. I don't believe that it needs to be in the form of a legal brief. While sometimes case law is important, usually it's a matter of the facts and figuring out uh, what one side believes the other side did that is wrong. So I believe that mediation statements are an important component. I request that they be 10 pages or less, not including exhibits. If people want to give me copies of bank statements or documents or contracts or any other document, I think that's great. And I'm happy to look at those in advance. A question that comes up is whether or not the mediation statement should be shared or confidential. Some mediators use a hybrid where there's a shared portion, but then part regarding the efforts at settlement and what the parties are willing to settle for remain confidential. I have found that to be somewhat confusing. I think that generally the lawyers know what the other side thinks. There's probably already been pleading. Certainly there's been a complaint, there's been an answer. There may have already been motions to dismiss. There may have already been motions for summary judgment or summary adjudication. So I don't find it particularly necessary or useful for the mediation statements to be shared between the parties. But of course, if all of the attorneys wish for their statements to be shared, I have no objection to that. But my preference and my history has been not to share them. So then we get to the mediation itself. And just like I'm attempting to look at the camera so that you can see my face and see my eyes and get a sense of how I am feeling, it's very important to attempt to make the mediation as lifelike as possible. And so all of the participants, especially when they're speaking, but even when they're not, it's important that the camera show the people who are in the particular room. So I find it useful to set up the camera either by having all of one side sit on one side of the table or have the camera be of a wide enough angle so that if people are on two sides of a table, you can see everyone at the same time. I mean, let's be honest about it. People will show visceral reactions to different statements. And it's important for the mediator to be able to read the people, not just what they've said, but how they respond in determining how far you can push someone in trying to make a deal. One of the things that we try to do in mediations is let's try to get to the point. So if the people are sophisticated in legal matters and have done this before, I find it unnecessary to spend the time in what's called a plenary or joint session where the different parties are all together. But sometimes, especially in matters that may be personal, the parties need to get something said and they want the other side to hear it. And if that's the case, then you can create the opportunity for everyone to be in a room together to get started, lay out the groundwork, and offer the opportunity for the lawyers and for the participants to make a statement. And then, depending on whether or not that leads to further conversation as a group, or whether at that point it's useful to then go into the breakout rooms, that's what you should decide sort of as the mediation progresses. In the Central District of California, the mediation panel, the mediators agree once a quarter to provide a free mediation of 4 hours or less. Now, many mediators, including myself, are willing to go as long as it takes if progress is being made. But remember, people are doing this voluntarily, and the time is valuable, in addition to the fact that the mediator has spent time in advance reviewing the mediation statements, reviewing the exhibits, having a test run, maybe speaking to the attorneys in advance to ask questions. All of that is being done voluntarily. So while sometimes it is useful to put the parties at ease and maybe have a little bit of chit chat, talk about the pandemic, talk about the family, talk about whatever mutual topic there is, I find it unnecessary to use a lot of time in what is not really at the matter at hand. So with that, when we start the mediation, I like to do pleasant introductions, say hello, but not spend a lot of time catching up on what's been going on in your life. We can do that another time, but let's just get down to the mediation. Another benefit of using Zoom is that you have the ability to screen share, which is what I'm doing now, I hope. And if parties have documents, and sometimes they do, they will have two forms of a contract, or they will have a signature that they claim was not signed by them, but signed by somebody else. Many different opportunities where documents ought to be shown and shared if agreed to. You can use Zoom by simply opening up another screen where that document is located and sharing it with the other side. So I think part of what you need to do in advance is decide whether there are any documents that you would like to share, and if so, have them loaded either into a share file if they're voluminous, or just if it's a single piece of paper, have it as a PDF. You can open it up within your computer and then do the screen share and be able to show it. If there is an agreement, it is imperative that it be put into writing and signed by all of the parties at the mediation. Now, that doesn't mean that it has to be a long form agreement where all of the boilerplate items that are normally found in a settlement agreement are included. But it is very important that all of the salient points of the settlement agreement are put into writing. It is my preference as the mediator not to be the scrivener of the agreement, because I am not a party to the dispute. After the mediation is over, I don't want to be called upon to ask to interpret what was agreed to. So what I usually ask is that one of the parties agree to write down the settlement agreement in a bullet point fashion and then share it. It can either be shared with me and then I will share it with the other side, or the parties can be put together into a single room. And then when it is fully agreed upon, then it should be scanned and distributed via email, which can be utilized during the mediation, and everyone sign off on it and share the signatures. And that way, there isn't a dispute later on as to what was agreed to. I unfortunately have war stories, many of you probably do too, about the parties shaking hands. You know, it's late at night, everybody's tired. They say they'll come back tomorrow and sign, and then suddenly overnight they think of all kinds of other problems with the settlement agreement and they don't want to sign. A signed bullet point settlement agreement is enforceable. And so I believe that one of the most important aspects of a mediation is signing the agreement at the time. So with that, I'm going to attempt to stop the screen share. Well, I guess there was one more, was my resume, but I guess you all know who I am. I'm the managing partner of SulmeyerKupetz. We're a 67-year-old law firm headquartered in downtown LA. We've practiced primarily in the area of bankruptcy and insolvency, general business matters. I represent all different parties in bankruptcy cases. I'm a mediator, I'm a bankruptcy trustee. I wear a lot of hats. I don't know who that handsome guy is on the screen there, but I don't recognize him. So with that, I will stop the screen share. And if there are any questions, then I'm happy to take them. Okay, thank you. Somebody complimented my front yard. I'll tell my wife that you liked her roses. But does anybody have any questions about the mediation process or how to conduct it using technology? Okay, well, I see that we've got 30 people on the line, which is terrific. Hi to my friends. Hi to people that I don't yet know, but I'll certainly be following up with you after this call. And let's see, we do have a question. At the end of the day, people are exhausted and fail to consider all the salient points before they leave. Any suggestions? Well, I think the answer is, while the parties may not, the lawyers do. The lawyers generally know what needs to go into a settlement agreement, you know, the amount to be paid, when it's going to be paid, what releases are going to be made, whether there are any transfers that are going to take place, when would those transfers take place. And so I think if you make sure that the lawyers are capable of still handling it, that's okay. I agree that the parties, especially if they're not legal savvy, may not know all of the issues that need to be dealt with, but I think the lawyers can. Ben, yes, you'll get a half an hour of MCLE credit, and nice to see you. Hope all is well with you. Okay, let's see. Should an attorney and his or her client be physically together when participating, or can they each participate from different places? That's the nice thing about using Zoom, is that the parties don't have to be with their lawyer, and the lawyer and the client can speak privately. When the mediator leaves the breakout room, the parties are still there and able to talk to each other. So if it is inconvenient or difficult for the party and their lawyer to be physically in the same room, they don't have to be. And they could be assured that they will have privacy when they want to speak when the mediator is not present. Howard, do you review the settlement agreement and point out things which you believe are missing? Yes, I do. Again, I don't get into the actual settlement, but I do try to make sure that the settlement agreement includes all of the basics. I have a form that I have used in the past that I can share, which is a basic template of a settlement agreement. And so that can be distributed, and it has several provisions so that most everything that would be in a settlement is on the form, and I'm happy to share that if anybody likes. All right, well, I appreciate the questions and the opportunity to speak with you. I'm always available, so if you have any questions after this. Let's see, 2 people raised their hand. I don't know what that means. I guess somebody's just waving hello to me. Okay. All right. I'll wave back. So again, thanks very much for participating today. And I hope you all have a great day. Okay. Thanks a lot. Take care. Bye-bye.